for the third time in my 40-year career, I received an order from a court today placing the defendant husband in jail. My name's Ken Novenstern, Fredman Baken Novenstern, LLP, and today I'm talking about contempt and enforcement in matrimonial cases. So when the parties enter into a stipulation of settlement and a judgment of divorce is signed, or there's a judgment of divorce rendered after trial, and the parties are required to do certain things, such as pay one half of the retirement assets to the other party via a quadro, or pay money in general, or pay support. Those are parts of the judgment of divorce, which is a court order. And if someone fails to comply with the terms of the court order, they can be held in contempt. And in New York, one of the penalties for contempt is incarceration for up to 6 months. And typically what the judge will do, as the judge did in my case today, because the defendant was not present in the courtroom, the judge issued a bench warrant for his arrest, directed that he would be incarcerated for a period of 6 months. The judge set a purge amount of several $100,000 so that when he is collected and brought before the court, he will be given the option of paying the amount of several $100,000, which is a portion of what he owes, as a way of purging his contempt and avoiding jail time. This gentleman went through this process once before, about 6 years ago, and spent several days in jail before he paid a purge amount. And so contempt proceedings are very difficult. I think they're very confusing to people. Contempt really is just someone failing to pay something that they're required to pay pursuant to a court order. A judge will not automatically grant contempt based on one violation of a court order. There has to be more than that. But it is a remedy in enforcement proceedings in New York. So if you're in a situation where your spouse has failed to pay something significant in the context of your agreement and judgment of divorce, please feel free to contact me concerning enforcement proceedings, and we can discuss the options and the various considerations. Again, my name is Ken Novenstern, Fredman Baken Novenstern, LLP.